Good afternoon, everyone. We're just going to give a few more minutes for additional attendees to sign on. I guess we'll go ahead and get started. First, let me just thank everybody who has signed on for attending today's webinar. Today's topic is really part of a three-part series that we're going to be presenting on. Today's will be, what the next steps are for J-1 international medical graduates who have or are in the process of completing residency and fellowship training. So let me start by introducing myself and my colleagues. To my left is my colleague Nora Katz, and I am Vin Duong. Collectively, we've been practicing immigration for over 30 years now. We have probably over combined experience of 25 plus years in the healthcare immigration space, specifically dealing with J-1 waiver physicians and other kind of allied healthcare professionals. All right, so as I mentioned, this is part one of a three-part series covering various topics that impact international medical graduates. For those of you on the call, you know that as an international medical graduate, many of you will do your training on a J-1 visa. And that J-1 visa has a special condition attached to it, which is at the conclusion of your training, you are required to return back to your home country for 2 years. Now, to avoid this 2-year foreign residence requirement, those of you in J-1 training will have to apply for what's called a J-1 waiver. Now, there are different kinds of J-1 waivers. There are J-1 waivers based on hardship. There are J-1 waivers based on persecution. But most commonly, the waivers that we see are J-1 waivers where the physician will work in a medically underserved area. Hardship waivers carry their own requirements. I'll just quickly cover what those are. You basically, as a J-1 non-immigrant, have to show Homeland Security and the Department of State that returning back to your home country for 2 years or remaining here for 2 years by yourself would create a personal hardship to your family. So with hardship waivers, you're not having to prove that the hardship impacts you necessarily, but that separating from your family or remaining here by yourself would create the hardship to your family members. And those family members have to be either US citizen family members or lawful permanent resident family members. And then there's the persecution waiver, which really is applicable to J-1 non-immigrants who are going to be subject to persecution if they were to return back to their home country. This standard is much more narrow and much more specific as compared to someone who's applying for asylum, where you have to show a well-founded fear of persecution. We don't really see a lot of persecution waivers, filed through our office, but from time to time, there will be, IMGs who will call us to ask questions about the persecution waiver process. But again, the majority of the waiver applications that our office files and that we see really typically impact doctors who are working in medically underserved areas, which Nora will cover now.
So most international medical graduates are going to request their J-1 waiver through either a state Department of Health or through a federal agency. The state J-1 waivers are run through a program called the State Conrad 30 waiver. Each state has 30 waiver slots that it can give out in every year. And then there are several federal agencies that also will award J-1 waiver slots, including the Health and Human Services Department, the Delta Regional Authority, the Appalachian Regional Commission. So each state, each federal agency has its own requirements for the J-1 waiver, but there are some common requirements no matter where you apply through. So you'll need to find an employer to sponsor you for the J-1 waiver. You need to have an offer to work in an underserved area. So that's a location that's been designated either as a health professional shortage area or a medically underserved area or population by the federal government. And you also need to commit to working in that underserved area for at least a 3-year period. Beyond those basic requirements, each state does have its own requirements and its own timing considerations. There are some states that run out of their J-1 waiver slots right away. There are other states that never use up all their waiver slots. So those are factors that come into play when you're looking for a job, when you're considering where it makes sense to apply for your J-1 waiver. And that's a question we get all the time is, when do I need to start the J-1 waiver process?
Yeah, when we do consults with a lot of our clients, this question really comes up a lot, and really the key for you all from the perspective of being an international medical graduate is you really have to start the process, as Nora mentioned, early. In addition to identifying an employer, the majority of waiver programs open up in October. So just to give you an example, if you are a 2022 graduate, you will want to start looking for a job to remain in the United States right around, now or earlier. And the reason for that is because most J-1 waiver programs will open up October 1. Some even open up earlier than that. So just off the top of my head, like Georgia, for example, they will start accepting waiver applications in September. In Kentucky, for example, they open up October 1, but they only accept waiver applications for a 30-day window. And the same is true with several other states, including Kansas and Alabama. Now, Alabama is unique if you're applying for a job there, because in addition to opening up the program October 1, if you are a specialist, non-primary care physician, they will not start accepting your J-1 waiver application until the first Monday of the first in January of the following year. So that's really important for you from a timing perspective to understand when you need to start looking for a job and doing your site interviews. Because there is a lot of legwork that's involved, not only with you making the site visit, but also with your prospective employer, making sure that they've conducted all of the requisite recruitment to prepare a J-1 waiver application for you. And as you'll note on this slide here, starting the J-1 waiver process early, it optimizes your chances of securing a waiver slot for the particular agency where you're wanting to file, or the particular state where you're wanting to work. And then it also will leave you enough time in the event your application is rejected to submit a second waiver application through another employer. It's rare in our office that we see cases get rejected, but from time to time it does happen. Like in North Carolina, to give you an example, we filed one a year ago where they only set aside 10 waiver slots for specialist physicians. And within literally a matter of a week, they ran out of those 10 slots. And we happened to submit our application right around the time when they made the announcement that they had secured, or they had allocated all 10 specialist slots. And so we were number 11 out of 10. And so that physician candidate had to secure employment elsewhere because there were no slots available for him. So that's an example of why it's really important to start the process. And so really the takeaway from this particular slide is, if you always want to look for a job at least 1 year before your graduation date. So if you're a 2022 graduate, you need to start looking for the position and getting your waiver application filed in 2021.
So once you have identified an employer, a sponsor, the next question we hear a lot is, well, what does this whole process look like? The first step is putting together all the documents to file the J-1 waiver with either the state health department or the federal agency. That's the step that's going to be a lot of legwork on the physician side. You'll need to gather your immigration documents, copies of your DS 2019s, copies of all your credentials, so education documents, training documents, USMLE results, and also whatever other specific requirements that state or federal department has. Those can be things like some states require you to have submitted your medical license application already. And so those are all steps that kind of have to happen on the front end and can slow down the ability to file the waiver itself. Once the waiver application is submitted to the state health department or the federal agency, it usually takes about 1 to 2 months to get a response. It depends on the state or the agency. Some states, as been mentioned, will have a period where they accept applications. So they'll accept your application for 30 days and then they'll close the program and review all the applications they've received. Other agencies will review on a rolling basis as applications come in. So that can change how long it takes to get an answer on whether or not your application is going to be accepted and recommended. Once the state health department or the federal agency recommends your J-1 waiver, it'll be sent along to the Department of State for their review. That process takes about 2 to 4 months. There's nothing else that you need to submit at this stage. It's just kind of a waiting game until we receive the recommendation from the Department of State. And then your application moves along to the Department of Homeland Security, which reviews and grants the ultimate approval of the J-1 waiver. Now, the J-1 waiver doesn't give you any status in the US. It doesn't give you work authorization. It just waives that home residence requirement. But in order to complete the 3-year work commitment for the J-1 waiver, you also need to apply for H-1B status. That 3-year commitment has to be completed in H-1B. So once the Department of Homeland Security has the J-1 waiver application, at that point you can go ahead and file the H-1B petition. H-1Bs can be premium processed, so it's possible to get an answer pretty quickly on those, usually within 15 calendar days. And then once you have the H-1B approval and the J-1 waiver approval, you'll be able to start working to fulfill the 3-year commitment.
So just to add on to what Nora was saying, you can see on the slide the approximate time it would take to get all these various agencies to approve the various steps of the J-1 waiver process. We typically will tell our clients that the processing time will take somewhere between 4.5 to 5 months. And with COVID, we've seen these agencies take a little bit longer with processing J-1 waiver applications. So that's going to be important for you all to get the process started early because of the amount of time it takes these various agencies to process your application. Nora alluded to the fact that one of the agencies that we would file waiver application through is also the Appalachian Regional Commission. So when you file through the ARC, just as an example, that's another agency that gets added to the various entities that are working on your application. So now you have the ARC, the state where you're filing the case, the Department of State, and then Homeland Security. So all those various agencies have their own, processing times for these types of cases. So those things have to be factored in when you're starting the application. And we'll cover this in a little bit, but one of the things that you'll need to explore is whether or not you need to extend your DS 2019. So during the waiver process, the 3 big things that we get questions about from international medical graduates is, can I travel before, during, or after my J-1 waiver has been filed? What about licensing? And then do you recommend that I extend my DS 2019? So the slide prior to this one, Nora alluded to the processing times involved with the J-1 waiver process. Depending on where you are in terms of like getting the process started, whether you've done a site visit or you've met with the employer, you may need to extend your DS 2019 form. Residency programs, as you all know, typically end June 30 of whatever year that you finish your program. So let's just say, for example, you finish your program June 30, 2022. If you're starting the J-1 waiver process now, it's unlikely that you'll need to extend your DS 2019. But if you push out the decision to join an employer much later into the year, for example, let's say into November or December, then it's most likely you're going to need to extend your DS 2019. And the reason for that is if it takes 5 months for all these agencies to process your waiver, you have to build into it a safeguard in case it takes a little bit longer for them to process your application. So we typically tell people, if you're starting the process now, you're in pretty good shape as far as timing is concerned. So it's probably not likely that you'll need to extend your DS 2019. But if you delay the decision to join an employer, with each passing month, the likelihood will be you'll need to extend the DS 2019. And the reason most IMGs will request to extend is to sit for their board exams. So if you're an internist, for example, most internal medicine board exams take place in August. So if you finish your training at the end of June and you're planning on sitting for your board exams, ECFMG will extend your J-1 status all the way to the end of August. And then plus after that, an additional 30-day grace period. So now you've bought yourself several more months to get all your immigration paperwork filed and in order before you start working.
I think it's worth noting when thinking about extending your DS 2019, you do want to start that process fairly early along in the J-1 waiver process too. Once you've received your J-1 waiver application, you won't be eligible to extend your DS 2019 anymore. So if that's something you think you might need, it's worth doing that early on in the process.
Yeah. And honestly, it doesn't hurt to do it.
Right.
To the extent that you have to contact ECFMG, that's probably the only burden that really falls on you to do. But my recommendation would always be to extend just in case you need it.
Yeah.
But Nora raises a really good point about making sure that you're doing it timely, because once the Department of State recommends your waiver, you will not be able to extend your DS 2019 anymore. So the other two issues that we get a lot of questions about is travel. Prior to filing your J-1 waiver, you are eligible to travel and return to the United States, provided you have a valid J-1 visa stamp in your passport. You have a DS 2019 that's been endorsed for travel by your responsible officer at ECFMG. And you are still in valid training in the United States. So all those things, if you're traveling before the waiver application is filed, you're eligible to do so. And those are the things that you need to make sure you have. Once the waiver application is filed, we do not recommend travel. And the reason for that you see is once the waiver application is filed and you travel, you could re-trigger 212E, which is the requirement of having to go home for 2 years. And why is that important? It's important because if you re-trigger 212E, we have to start the process all over again to apply for your J-1 waiver, which we obviously want to avoid duplicating our efforts. Now, post-travel, once the J-1 waiver application is approved, once your H-1B change of status is approved, you are permitted to travel and return to the United States. But when you return, you would be coming back in H-1B status. So typically people who are traveling post-filing are waiting for both the J-1 waiver and their H-1B to be approved before they travel internationally. And then, just obviously to state the obvious, when you're applying for a visa with COVID restrictions in place, there are travel bans and visa bans that you need to be aware of that will impact your eligibility to apply for the visa stamp, regardless of when you're deciding to travel. And then lastly is the licensing piece.
So the medical license is required for the H-1B petition, and that can create problems at different stages in the process. Some states do require that you submit the medical license application as part of the J-1 waiver application itself. So that can slow down your ability to file the J-1 waiver. The medical license applications are generally pretty involved, require a lot of documentation. But on the positive side, you will likely have your medical license in time to file the H-1B. So slows it down in the front end, but keeps the process moving once we get to the H-1B stage. Some states won't issue the medical license until you've completed your training, particularly with residency training. Now, this can create kind of a time crunch when it comes to filing the H-1B. If your program ends June 30 and we have to get your H-1B petition filed before July 30, that means we need to have that medical license somewhere in that 30-day period. And most state licensing boards are aware of this, and they will generally process licenses for international medical graduates pretty quickly once the program is completed. What you should do if you are in a state that won't issue a license until you've completed your training program is still submit your application early, follow up with the licensing board, make sure that they have all the documents, and also check in with your program coordinator, your program director, to make sure as soon as you complete the program, they send that completion form along so that your application can get processed. What you don't want to happen is you get to July 1, your program's complete, and then you find out that your application is missing other documents, and so the license can't be issued. Because that can throw off the timing of your H-1B and your ability to change your status in the US. And then another issue that comes up fairly frequently is some states won't issue you the medical license until you have received the H-1B approval notice, which is problematic because we can't file the H-1B until you have the license. It ends up being a little bit of a catch-22. The workaround for this is the state licensing boards will not issue you a license, but they'll issue you a letter that says this physician's application is complete, all the documents have been submitted. The only thing we're missing is proof of their immigration status. That letter can be used in the H-1B petition, and the Department of Homeland Security will issue a 1-year approval of H-1B status. You can then take the H-1B approval notice, send it back to the state licensing board, and they'll issue you the permanent license or the medical license. Because you need to complete your whole 3-year waiver commitment in H-1B status, you then need to file an H-1B extension to get the full 3-year period using the medical license. So it's a little bit more cumbersome, but it's a very common practice. And there are several states, including Tennessee, where we are, that do require this but-for letter.
And just to add to that, we talked about extending the DS 2019. The licensing issue is an example of another reason why you would want to extend the DS 2019. As you can see, if you graduate June 30 and you're going to work in a state that won't issue the license until after you finish training, you only have a 30-day grace period to file the change of status application. And if you don't file within that 30-day grace period, well, then you'll have to wait outside of the US for your H-1B to be approved. So one way to counteract that would be having already previously extended your DS 2019, let's say to August. Now you've bought yourself several more months to remain in the US while the license is being processed. So that's just something to consider when you're looking at the reasons why to extend your DS 2019.
Absolutely. Now, after you do get your J-1 waiver slot, we mentioned several times that you have to complete the waiver commitment in H-1B status. The good news is by receiving a J-1 waiver, you are personally exempt from the H-1B cap. You may have heard of this. There are a limited number of H-1B visas available each year to work for-profit employers. That rule does not apply to physicians who've received a J-1 waiver. Your J-1 waiver makes you exempt from that cap, and that exemption attaches to you personally. So if you move to a new employer, to a new location, you remain exempt from the H-1B cap always. Now, that exemption does not apply for other types of waivers. So if you apply for a hardship waiver, you can waive the home residence requirement, but you are subject to the H-1B cap. And it also doesn't apply to J-2 dependents. So your J-1 waiver application does cover your family members. It gets rid of their requirement to return home, but they're still subject to the H-1B cap as well if they get an offer of employment in the US. We've talked a lot about timing and getting your H-1B filed and your J-1 waiver filed early. And one of the main reasons for that is because of how the H-1B has to be filed. There are two ways that the application can be processed, either as a change of status or as consular processing. Change of status is you file the H-1B requesting that DHS automatically change your status to H-1B without you having to travel. And so if they approve the H-1B, you'll get the approval notice, and there'll be an I-94 document on the bottom that shows you are now in H-1B status through X date. Consular processing, you still get the approval notice, but you have to leave the US, apply for a visa stamp at an embassy or a consular post, and then be admitted in H-1B status before you can start working in H-1B. You know, a lot of physicians do pursue consular processing. Either they have travel plans following their training, they want to go home and visit family, and that's fine. You just need to be aware that there are these extra steps before you'll be in H-1B status and be able to start working. A few kind of notes about consular processing. Canadian physicians don't need a visa stamp, so they can just take their approval notice, leave the US, re-enter, and start working in H-1B. It makes the process more streamlined for Canadian physicians. Consular processing is sometimes required depending on the timing of your case. So if you can't get your medical license, if you don't finish your training in time, if we don't have the J-1 waiver approval in time, you may be required to leave the US and wait until you have the H-1B approval to enter, if it's not possible to file the H-1B petition before your J-1 status or your grace period expires. Now, Ben mentioned this earlier, but because of the COVID-19 pandemic, our general recommendation is that you avoid travel as much as possible. There are a lot of travel restrictions, both to the United States and to other countries. There are limited numbers of visa appointments available, and a lot of those are being canceled as case counts spike in different areas. There are quarantine requirements in certain countries, and all of these different requirements remain very fluid as the situation evolves. So if it is possible to avoid travel right now, we recommend that you do. If you do need to travel, make sure you're checking on country conditions before you do so and applying for a visa application or appointment as early as possible to make sure that there aren't delays that prevent you from getting back to the US and starting to work. Once you do start working in H-1B status, there are a few requirements for your J-1 that continue on. Throughout the 3-year periods, you do have to complete reports to either the state health agency or the federal agency that issued your waiver that basically confirm you are working, you're working where you said you were, you're working 40 hours a week. And those would be completed by you and your employer. The state agency or the federal agency will send those along periodically throughout the 3-year waiver commitment. Now we keep talking about the 3-year waiver commitment and how you do need to complete that waiver in H-1B status. H-1B status is also granted in 3-year increments. So if you line up your start date perfectly and you're able to start right when the H-1B starts, great. You can finish the waiver commitment in one H-1B and continue on from there. Very often, physicians aren't able to complete that 3-year waiver commitment within the initial 3-year H-1B validity period. Either you start late or you take some time off. That's fine. You just would need an H-1B extension so that you can finish up the 3-year waiver commitment in H-1B status. So it's not an issue, just something to keep an eye on. And if you're approaching the end of your 3-year H-1B status and know that, oh, I've got a couple more months I need to do on my waiver commitment, it's worth mentioning to your employer, hey, we might need an extension here.
Okay, so this next part really deals with cases where you have been approved for a J-1 waiver. You are now working for the sponsoring employer, but the job doesn't work out for any number of reasons. So what's the recourse there? The recourse is, as an international medical graduate with an approved J-1 waiver, you have to apply for a J-1 waiver and H-1B transfer. Now, the J-1 waiver transfer is approved ultimately by U.S. Citizenship and Immigration Services, okay? But as a courtesy, you will always want to notify the agency that originally approved your J-1 waiver that you're seeking to transfer either to a new employer within the same state or to a new employer out of state. The reason for that is, although these agencies don't really have a say in whether or not to approve your transfer, they can make your life difficult by writing a letter to DHS saying that you've not been in compliance with the terms and conditions of your J-1 waiver. They could also make trouble for your sponsoring employer to sponsor other physicians later on down the road. So you don't want this red mark on your file. So as a courtesy, we always try to reach out to the sponsoring agency first. Now, some agencies are super helpful. They will listen to the reasons why you want to transfer, and they will issue a support letter saying that they concur with the transfer to a new employer. Some states, however, or some agencies aren't always so helpful, maybe because they don't really think the reason you're transferring rises to the level of extenuating circumstances, or they just don't want to give you up as easily as you just saying, I want to move to another employer. So in those instances, you have multiple options. I mean, option one would be obviously trying to get the letter from the agency to support the transfer to a new employer. Or option two is to file the transfer regardless of whether you get the support from the agency, and let Homeland Security be the ultimate decision maker on your eligibility for a transfer. Now, when we talk about a J-1 waiver transfer, you'll see on the screen that you have to demonstrate extenuating circumstances beyond your control. You wanting to move to a new employer simply because you don't like the weather in Minnesota, for example, it's just not a good reason. So there can be various reasons why you want to transfer to a new employer. Maybe your existing employer is not adhering to the terms and conditions of your contract. For example, they're not paying you what's agreed upon in the contract. Maybe they're having you work doing extra job duties in a medical specialty that's not really within your area of expertise. Maybe the employer is filing for bankruptcy. Maybe the employer is about to close its business. There can be any number of reasons to show extenuating circumstances. You can even show, in some instances, personal hardship to you as an extenuating circumstance. We've done these types of J-1 waiver transfers for doctors using personal hardship as a basis for the transfer, and it has worked. Now, those types of cases are on a more of a case-by-case basis, because you can imagine, your hardship may not be the same as someone else's reasons for wanting to transfer. So you have more of the clear-cut cases that are eligible for J-1 waiver transfer, such as the employer is not paying me my wages. The employer is about to close its doors. The employer no longer needs a full-time, internist in this particular location or this particular practice. Those are all legitimate reasons that would support a waiver transfer. And then you have the more ambiguous J-1 waiver transfers, like the personal hardship transfers, where you're going to have to provide, a lot of supporting documentation to build the case to show that, remaining in this current environment or with this current employer is creating a personal hardship to me and my family. The second thing you'll see for J-1 waiver transfers is you can only transfer to a designated shortage area, which means that if you're working now in a HIPSA or an MUA, if you're transferring to a new employer, either in or out of state, you still have to work in a HIPSA or an MUA. And then lastly, I've talked about the kind of the various steps that you have to undertake to get the waiver transfer. Reaching out to the agency that approved your J-1 waiver, but also keeping in mind that even if that agency does not want to play ball and they're not willing to give you that support letter, you can still file the J-1 waiver transfer, because it's USCIS that makes the ultimate decision on that. I think the big takeaway for anybody who experiences this situation in the future is definitely consulting with someone who has experience doing waiver transfers and getting an understanding of what truly is extenuating circumstances. And understanding that, although you want to be helpful to the state that approved your waiver, that it's USCIS that makes the ultimate decision on that. Okay.
So another question that we get a lot, especially when we're advising people early on in the J-1 waiver process, is what happens if I don't get a waiver slot? What if I decide I want to apply for a slot in Texas? I found this job and there are too many applications received, and in my case just doesn't get picked. I think it's worthwhile to kind of go through the different options available to you when you're making your plans, so that you have a realistic expectation and backup in mind in case your placement doesn't pan out. As we've mentioned, different states are, I guess, more popular, maybe isn't the right way to put it, but they receive more applications for the same 30 slots, no matter what state you're in. So a lot of states, Texas, California, New York, will run out of their slots right away. You can certainly still file there, but you may not get picked. And so if you're planning to file one of those applications, it's good to have a backup in mind. If you're starting the process early, you may be able to file another waiver, either through a different state Department of Health or through a federal agency. You'd want to be careful to pick a state that has slots still available. So you wouldn't want to go from Texas to California, because you won't be able to get your application submitted in time to get a slot. Or you can apply through a federal agency. Now, the federal agencies don't run out of slots. So we have seen people apply much later for a J-1 waiver through the Delta Regional Authority or the Appalachian Regional Commission, and still be able to get the J-1 waiver and apply for the H-1B in a timely manner. Now, when you're filing a second H-1B, or sorry, a second J-1 waiver application, you're naturally going to be farther behind the curve. If you file your first waiver on October 1st, get the decision, I don't know, mid-October, November, by the time you turn around and get your next application submitted, you're going to be looking at probably starting the process in December. And if you recall from that chart earlier on, there are several months worth of processing to get through. That would be a scenario where you probably do want to extend your DS 2019 if possible, to give you enough time to get the H-1B filed. You can also file a different type of waiver, such as a hardship or persecution waiver. Now, for the J-1 waiver through a state health or federal agency, you can only have one pending at a time. So I couldn't file an application in Tennessee and at the same time file one in California and think, okay, I'll take whichever one I'm going to get. You have to pick one. You have to attest on your application that, yes, I only have one application pending. But that same requirement is not true for a hardship or a persecution waiver. You can go through the state health waiver process while also pursuing a hardship or persecution waiver. So that is, if you qualify for those other types of waivers, that can be a good backup. There's also a visa called the O1 visa that is available for extraordinary ability. So this is for physicians who are considered to be at the top of their field. Now you have to be able to prove you're at the top of your field, which can be a little bit difficult. The criteria that the Department of Homeland Security looks at is really focused on things like research, publishing a lot of scholarly articles, making original contributions. So it can be more difficult to prove O1 caliber for people who are clinicians, even if you are an excellent doctor. There's just less documentation to establish that fact. So if you're thinking about doing an O1, a good place to start is looking at your CV. If you have a lot of publications, if you've done a lot of presentations, you might be a good candidate for an O1 visa. A few issues with the O1. First of all, it does not get rid of your home residence requirement. So you still need to get a J-1 waiver at some point, switch into H-1B status and fulfill that 3-year waiver commitment. The O1 is really sort of a stepping stone or a stopgap. So if I don't get my J-1 waiver this year when I finish my training, okay, I can go into O1 status, work for a year, and try applying again next year. But I do still ultimately need that J-1 waiver in order to eventually apply for an adjustment of status. The other problem with the O1 visa or issue to be aware of, I suppose, is that you don't qualify for a change of status from J1 to O1. You can only change status from J1 to H1B. So if you do get the O1 approved, you'd need to leave the US, apply for the visa stamp, and then re-enter an O1 status to start working. And given the current travel restrictions, that can be a little bit more difficult than it normally would be. Now, Canadians, again, don't require a visa stamp, so the O1 can be easier for them. They just leave, re-enter with the O1 approval notice. Canadians are also able to be sponsored for a CAP subject H-1B petition. There's a limited number of H-1B visas available each year for for-profit employers if you're not exempt from the CAP. And so this sort of workaround would be for people who didn't get their J-1 waiver, so they are not exempt from the H-1B CAP, but find an employer, a for-profit employer who wants to sponsor them, are selected in the lottery, get the approval, and then would leave and re-enter. But this also would not get rid of your home residence requirement because you haven't received the J-1 waiver yet. So if your ultimate goal is to stay in the US, you are going to need that J-1 waiver at some point. These options are just kind of ways to serve as a stepping stone until you're able to get the waiver for the location where you want to work.
I'll just add one thing about the O1 visa. You know, most J1 non-immigrants will use that O1 visa really only as a bridge to help them stay in the US while they get their J1 waiver approved. And we typically don't see people, IMGs apply for O1s unless something, you know, unless they're not getting the J1 waiver that they want, or they're late in filing, or an application has been rejected. So this O1 is a nice alternative because it does allow you to remain in the US while you're working in the background to file that J1 waiver application. So a lot of J1 international medical graduates will ask us, you know, well, at what point can I apply for my green card, or can I apply for my green card? And the answer is yes, for sure. You are eligible to start the green card process. In some cases, depending on which option you select, whether you want to apply for a green card based on a national interest waiver, or you want to apply for a green card based on a labor certification, that will dictate when you can apply for a green card. The green card options is one of the topics that we'll cover in our three-part series, but I'll just touch on it a little bit briefly. There are really two ways for an international medical graduate to get his or her green card. One is through the national interest waiver, and that essentially requires that you commit to working in a medically underserved area for an aggregate of 5 years. If you agree to the NIW, you can apply for your green card while you are still fulfilling your 3-year J-1 waiver service commitment, provided your priority date is current. And think of the priority date as just a placeholder in line that kind of dictates when you can apply for a green card. I often give the example of going to a busy deli, getting a ticket number from the deli. When they call your order, when they call your number, that's when you're able to place your order. The priority date is just like that. When you file certain paperwork with Homeland Security, they assign a date to your case. And that date establishes your place in line to apply for a green card. So only when that date is called up will you be eligible to apply. So to give you an example, let's say you had a physician who was born in India, and that physician says to me, well, can I file my NIW and my green card, concurrently so I can get a work permit for my spouse? The answer to that is probably not, unless your priority date is current, which we all know for India, they're backlogged for about 10, 12 years right now. But let's say you're a physician born in Germany. My answer would be completely different, which is yes, for sure. We can file your NIW and green card together while you are still in the process of fulfilling your 3-year commitment with your employer. And why is that advantageous to file an NIW? Some people do the NIW because they have spouses who need to work, and getting the spouse a work permit through the green card is one way of getting them work authorization. The opposite of the NIW is what's called the perm labor certification. And that requires your sponsoring employer to undertake recruitment to show the Department of Labor that sponsoring you for a green card would not displace a US doctor or take a job away from a US doctor. And so that process requires the sponsoring employer to undertake recruitment to show that they've tried to recruit for your position, but they've not been able to identify any able, willing, or qualified US doctors for the role. That process has some risk involved because obviously when you run recruitment for a job, you may find people who are able, willing, qualified, and available. I often get the question, well, it seems counterintuitive. I already have the job. Why is my employer having to run recruitment for my job? And the answer is don't look at it from the standpoint of a real world recruitment campaign. Look at it as your employer testing the labor market to see whether or not you would displace a US worker. So those are the two main options. Some physicians will also qualify for an EB-1 petition. As Nora alluded to, if you had previously applied for an O1, or even if you didn't apply for an O1, if your CV has enough publications and presentations and awards and things of that nature, you might qualify for an EB-1. And that might be advantageous for some of you who are on the call now who were born in India, because filing an EB-1 petition would fast track your eligibility to apply for a green card. That way you wouldn't have to apply for EB2 or EB3 classification. But those are essentially the two main ways in which we see a lot of international medical graduates apply for permanent residency is either through the NIW process or through the labor certification process. I will add one more thing to that. I find that a lot of our physician clients who were born in India will like to do the NIW because it gives them flexibility to move jobs where they're not tied down to a specific employer. The perm process is employer specific, so you have to have a sponsor there. So if you were to be sponsored by company A and then you leave company A, you can't take that labor certification with you. Your new employer will have to start the process all over again versus the NIW, which gives you more flexibility to move around.
Another perk of the NIW for people who are born in India is it typically can be filed faster than you would be able to file the perm petition because you don't have to go through that testing of the labor market. So you can secure an earlier priority date in most cases.
Yep. And obviously securing the priority date for anybody in a country where there's a long backlog for green cards is really critical because the sooner you get that date established, the sooner you get to secure your place in line to apply for a green card. And since we're on the topic of priority dates, I would just add this. If you have a priority date that is transferable to another employer later on, if you have to file a new I-140 petition. But again, this topic of the green card is we'll dive into this much more deeply when we cover this in our July presentation. I think that is the bulk of our presentation. We'll open it up for questions if anybody has any. Question? Nora, anything you want to add?
No, nothing really about this presentation, but if you do have questions, our contact information is included, so
Yeah.
please feel free to reach out.
Oh, all right. So our contact information, if you need to reach out to us, is here.
Yeah.
And
I think a lot of what we talked about today is very kind of general, and I think you can tell from some of the examples we gave that there are specific issues that come up depending on where you apply.
There's a question.
Okay.
Sure.
Can my spouse work during the waiver process?
So the question is, can my spouse work during the waiver process? So I'm assuming your spouse is in J2 status, and J2 status is eligible for work authorization. Now, keep in mind that work authorization is only permissible while you are in J1 status. So when you're done with your residency training, let's say June 30, 2022, your spouse would no longer be eligible to extend his or her work permit beyond June 30, 2022.
And when you're in H-1B status, the dependent status for spouses is H-4. H-4 itself doesn't allow for work authorization, but if you have an approved I-140, it's possible to apply for an employment document while in H-4 status.
Any other questions? Okay. Well, if you would, we'll be sending out additional fresh invitations for our June and July webinar. We'd love for you to come back and listen to those two sessions. Thank you very much for joining us this afternoon. And again, if you have any questions, feel free to reach out to Nora and myself.
Yeah. Oh, no problem.